Good evening and welcome to the webinar. This evening's webinar is avoiding the 3 common traps that separating couples face. So I'm briefly going to introduce myself and then give you a bit of an overview of what family law is and cover off the 3 main traps that I've seen over my last 13 years of practice, and to give you an idea of how to not fall into those traps, and basically to help yourself in the situation that you find yourself in. The webinar will go for about half an hour and we'll have questions at the end. So there will be a question and answer box where you can submit your questions. So type those in as we go. I won't look at the questions though until the end, and I'll answer those. And I may have to answer them via email. So we'll see how we go with this platform. Next slide. So, by way of introduction, my name is Jacqui Brauman. TBA law is my business. I've been running that for about 7 years. I worked for a number of firms and companies prior to going out on my own. I did a significant amount of work in family law. Once I started my own business and grew it to the size where I could hire another solicitor, it was a family law solicitor that I first hired, because family law is a really difficult area and it's certainly not something that I tend to take clients in anymore. So it's other solicitors in my firm who do the family law. That logo beside my photo is an accreditation which I got through the Law Institute of Victoria after doing my master's degree in wills and estates. So that's my specialty area. And there's only about 80 of us in Victoria out of about 12,000 solicitors who have the accreditation in that area. Now, I don't have the accreditation in family law. However, I do have over 7 years of pretty much practicing family law exclusively. And then since starting my own business, overseeing other solicitors who are doing it and helping them with their cases. Now, as a lawyer, I am a solicitor, not a barrister. So barristers are also a form of lawyer. Barristers are the lawyers who tend to do the court work. They are specialists in advocacy, whereas solicitors are the lawyers who work directly with clients, and barristers subcontract to clients. So solicitors can also do court work, and quite a lot of my solicitors do their own appearances, as do I do my own mediations. But as well as being a lawyer, I'm also a human. I'm a wife and a daughter and a sister, and a mother to my fur children. So in the photo in the bottom there, you can see my husband and my dog. We're out on the boat on Eildon. We do a lot of fishing, and that's how I get some downtime. Before I go on to the first trap, I wanted to give you a bit of an overview of what family law is. So the Family Law Act, the current act that we've got, has been around since 1975, when they removed the fault requirement for divorce. So divorce and family law work are not the same. I do recommend that you get a divorce. But when you do that is something that you need to strategically work out with the solicitor that you end up working with. Once you divorce, there is then 12 months from that date to commence financial settlement proceedings. So it can be strategic in some matters to divorce as early as possible. In other matters, you do the divorce at the very end. So family law is basically the separation of financial assets between parties, and that is both married couples and de facto couples, same sex or otherwise. And it is working out children's orders as well, so who the children are going to spend time with. Now, since this Family Law Act came in 1975, there's been significant changes to it. De facto couples have been included in it. And how they assess children's matters has changed significantly too, but not so much property settlements. What they have introduced are methods to try and keep people out of court, and those are the family relationship centres around Australia that the government funds. And as part of children's matters, when there are minor children, it has to be worked out between the parents who they're going to live with and how they're going to spend time with each of the parents and how major decisions are going to be made. Now, a lot of parents can work this stuff out between themselves, and that's fine. For those parents who are going to end up in court, it is a requirement that you go to try and see if you can prevent going to court. So a family relationship centre has a mediation process that is a requirement only in matters where there are children to get a certificate so you can go to court. It is my preference that those family relationship centres don't deal in the property issues because they don't have full disclosure to be able to do it. So that's moving into the first tip that I have for you. And that is bad advice. So traps that couples fall into. The first trap is either leaving getting advice too late, getting advice from friends and families and the person in the pub and their plumber and whoever else who's not a lawyer, and going to a family relationship centre first. So they're getting advice from everywhere but a lawyer, or they're not even getting any advice. If you can get advice before you separate, even better. Just come in for some strategy. Come in to find out what your rights are, where you stand, how to prepare yourself. And it doesn't have to be an immediate ongoing matter. Have 1 or 2 sessions. Your information is on file so that when you've actually separated, whether it takes a couple of months from when you first see a lawyer, you've got a lawyer to go back to once it's done. Don't separate, leave the home and leave it for 12 months before you do anything. Don't separate under one roof in the house and start divvying assets up between you without having got advice. And certainly don't listen to family and friends, because even if they've gone through a separation themselves, family law is a really subjective area of the law. There's not really a mathematical formula. It comes down to your circumstances and your assets, and no one's going to have a full picture of that. And with the family relationship centres, as I said before, they've got their purpose. And yes, you do have to try mediation if it's appropriate and there's children. It's not appropriate where there's only financial settlement to do if there's no children, and it's not appropriate where there is duress or family violence. So I have had people in the past go to a family relationship centre thinking they have to do it when they didn't. It was a situation where there was emotional and financial abuse. There were children, but the mediator dabbled in the family, in their financial settlement as well. And the family stayed in the same house after the mediation with a handwritten out agreement, so not necessarily binding. And there was shared care for the children, and it was just a ongoing emotional turmoil and trauma for this poor woman who was still living in that house, had not been able to get on with her life and separate herself from her ex, and was not able to parent in the way that she wanted to. So it was, in fact, worse than still being in the relationship. Now, the family relationship centres don't necessarily tell you either that what you agree to in their process is not binding until you take it back to a lawyer or a court. So again, because she hadn't had legal advice, she thought that was it, over and done with. That was what she was stuck with, and she put up with it for so long. It was just so unnecessary for her to go through that. And for the kids also to witness that dynamic between their parents was just not healthy whatsoever. So definitely not in the best interest of the children. Really only in the best interests of the Family Relationship Centre to tick off that they'd done another successful mediation to get their funding. So, yes, I'm a little bit cynical about that whole thing. But please, please, please go to a lawyer before you go to a family relationship centre, even if it's just for one session, so you know your rights and you know where you stand and you know what purpose the family relationship centre can serve for you. So that is the first trap. Oops. Next trap. Couples try to do it themselves. So yes, they may have a lawyer, but they don't have sufficient support in their life otherwise. So they don't have a counsellor, they might have some friends, they may have some family, but they do not have sufficient support. So just understand that your lawyer's role is to protect your rights and to get the best result, hopefully in the quickest possible way for you. And bear in mind, if there's children, and to pull you in line as well if you're not considering the best interests of those children. That can be a little bit of a conflict of interest situation for a lawyer. It's hard to do because, and this is why sometimes an independent children's lawyer is appointed, because they then just look after the children's rights, and your own lawyer doesn't have to then take the kids in mind as well. Although the whole purpose of the Family Law Act is to make sure the best interests of the children are taken care of. So your lawyer is not your emotional support. Your lawyer is there to look after your rights. Your lawyer is there for you to get advice from, to tell the whole story, to strategize and weigh up your options with, but not for you to lean on. Remember, your friends may or may not have your best interests at heart. They come to these things with their own experiences. They may play up your emotions. You really need either some kind of group or at least a one-on-one counsellor, so that you've got someone who is removed from the situation, unemotional, who can challenge you on your emotions, but also someone you can lean on emotionally. So I've had clients try to lean on me emotionally, and it's not good for either of us. I'm not there for them to be calling all the time, doubting themselves and wanting my emotional reassurance that whether they're doing the right thing or not. Again, that's not what your lawyer is for. Your lawyer is there for frank advice. Yes, they're an empathetic ear, but when it comes down to it, they're going to give you commercial advice on what is best for you subjectively, not emotionally. So please, please make sure that you've got sufficient support in place other than your lawyer. Those who don't have sufficient emotional support end up spending a hell of a lot more money sometimes on lawyers, because the whole thing plays out while their emotions burn through for about 12 months or more. The more emotional people are, the longer things can go for. So let's get our head in the right mindset and make sure you've got someone else to talk to other than your lawyer. Very frank advice, but if you want to spend tens of thousands of dollars of money that you don't really have to waste on lawyers, then don't get a counsellor. But if you want a quicker settlement with a more just and commercial outcome, then have a counsellor on your side. And trap number 3 is all around evidence. So you need to be keeping a diary. Even if you're watching this before separating, or you're watching it for someone who you know is separating, get a diary. Some settlements may go fairly smoothly, and then you won't need the diary, which is great. However, if you don't keep a diary and you do need it, then it may be too late if you haven't been doing it, because not every settlement goes smoothly. And surprisingly, your brain is not that great at remembering dates and events and the order where things happen. So please, please, please keep a diary, even if it's just a week to a double open page, so that you can jot things down when they happen. And then, you know, if you're in court 9 months later, you can flip back through your diary and you know exactly what date things happened. Time does fly, as you may or may not realise, and your memory is not perfect. So let's not try and burden our brains more when you're in a stressful situation by having to try and rely on it to remember things as well. Get a diary, keep everything diarised, and try and keep all communications in writing if you can. So if you can reduce all communications to text message and messenger, or some other kind of text format like email, then great. Do not use the public messaging over social media. Please don't post anything for people to comment on. People will know what you're going through. If you say anything, even if it's subtle, it can be used against you. So please don't put anything up publicly on social media. People can print out your posts on social media. Excuse me. People can even print out your personal messages. So you only put in writing what you're willing to, you know, have available as evidence. Don't swear, don't name call. All that stuff can be considered family violence, and it can go against you months down the track if things haven't settled. Yes, everything's emotional, but in emotional situations, it is my advice to try to sleep on things before you send them. So don't instantly respond in the heat of the moment. Nothing is usually that urgent that it needs an immediate response. Just go silent, respond to it the next day after you've given yourself some mental space, and please don't make anything public. So keep a diary. Helps with your evidence gathering, as does keeping communications in writing. Don't publish things on social media that can be used against you. If your ex-spouse is publishing things on social media, then gather it, take screenshots, and put it all aside. So that is trap 3 with evidence. Build your case. So those are your 3 traps. So I said at the start I'd introduce myself and talk a little bit about my experience and who I am. And then we've gone through the 3 traps. So getting advice from the wrong people, or not getting advice soon enough, not having adequate support other than your lawyer, and not building your evidence properly. So those are your three main traps. So what do you do? So you get advice early. You see a lawyer like us that gives you fixed fee quotes, so you're not going to be uncertain about what the fees are going to be. You get sufficient support so that you can do this separation smartly, intelligently, try and be as unemotional as you can, look after your rights, realize that you're not backed in a corner, find out what your rights are. That's your lawyer's role. Your lawyer has your back. Your lawyer will let you know what to expect and give you advice along each step. You're not powerless. This will resolve and life will go on and you will be fine. So that is basically my advice for anyone who's separating, to avoid traps that I see over and over again for people going through family law separations. And if you avoid the three traps that we've spoken about, your legal fees will be significantly lower than otherwise. So as I said, people get a shock over family law fees when they run out because people are emotional. People contact their lawyer constantly, lean on their lawyer for emotional support, get on to their email and do a couple of pages long ranting emails, emotional dumping. Find someone else you can dump all that stuff to and try to give as clear, factual, unemotional instructions to your lawyer as possible. Easier to say than do. I really do understand, particularly where there has been manipulation and violence in the relationship, and particularly, when it's quite a traumatic separation and there's young children. But look ahead in 12 months' time and realize you'll be getting on with your life then. And it's a matter of how easy or hard you want the next 12 months to be. So I hope that is a good start for you. Thank you for attending the webinar. I know how difficult it is facing a separation or going through a separation or helping someone else through a separation. But as I said, it does pass, and the result and the process depends largely on how you handle it. And so get some advice up front, and you're quite welcome to do that with us or another firm. So we have firm locations in Romsey, Wallen, Seymour, Nagambie, and we can see people in Melbourne as well. We can have initial phone appointments or Zoom appointments if you can't make it into an office. Our initial appointment fee is always $2.95. So you get an hour of our time for an initial appointment to find out where you stand for $2.95. Now, come as prepared as you can if you want an initial appointment by knowing your superannuation amount, your balance. Try to know your spouse's balance. Have a rates notice for your property, or try to have an appraisal from a real estate agent so you know how much your property is worth. Know how much is in your bank. Know how much your mortgage is. Know how much you're earning. All these sorts of things. And you'll be prepared enough for your initial appointment to get some really good grounding and know where you stand and be able to work out what sort of percentage you're looking at after separation, so you can start working towards thinking about how you can move forward, knowing what you're going to get. So give our office a call. If you call our main office at Nagambie, 5794 2334, They can make an appointment for you wherever it's most convenient, with whichever lawyer happens to be in that office at the time. So that number again, 5794 2334, and it's $295 for the first appointment. So thank you and good evening, and I wish you all the best.